Hi, how are you? My name is John D. Herrera. I'm a fellow American, and I'm here with Dan Marks, another fellow American. And we want to introduce ourselves, give you a little history of our political activism.
I am Dan Marks. I'm with Occupy Hawaii and recently with articlev.org or article5.org.
The highest law in our country is, of course, the Constitution. The Constitution is composed of 7 articles. The 7 articles are the structural law, and that is the law that basically sets up our government and sets up, there shall be a Congress, there shall be an executive, there shall be a court. And one of the features of the structural law is the Convention Clause of Article 5, and it says if 2/3 of the states ever apply for an Article 5 convention, the Congress shall call a convention. This convention, this Article 5 convention, doesn't seem like an institution to us today simply because we've never used it.
But I do want to go back to where you first learned of the convention. I don't recall ever being taught this in school. So where was it that you first learned about this?
Well, actually, it was, I grew up in Southern California. I grew up as your stereotypical surfer. In high school, I didn't go to school, really. I actually had to take 10th grade over because I was down at Zuma Beach for most of the school year. And it was taking 10th grade over. I was in a social studies class, and so I said, okay, well, if you're going to change America, it's got to start with the Constitution. So I went to the library and I sat down with a copy of the Constitution, and I just started reading. And as soon as I came across that phrase, "shall call a convention," the light bulb went off for me. I said, "Hey, we should have a convention." And then when 9/11 hit, the idea would not let me go that, hey, things are dangerous the way they are, and someone's got to be out there raising awareness of this issue. And shortly after 9/11, I was concerned about the vacuum of power that would be created by that event, and some bad guys might get in there and start doing stuff like writing up the Patriot Act, those type of things. And so shortly after 9/11, I began a journey, so to speak, to see if we can get a convention, an Article 5 convention in America today. And in 2004, I found Bill Walker, who's a constitutional scholar in Auburn, Washington, and he had a federal suit in the court system about the Convention Clause of Article 5. Now, his lawsuit was based on the fact that the congressional record showed that the states had satisfied the Convention Clause and that Congress was failing to carry out its obligation to issue the call for a convention. Bill's suit was in the Ninth Circuit Court of Appeals when I found out about it, and I started blogging about it, and just as a social scientist and political scientist, began talking to people about it. Now, when you get a suit to the Supreme Court, the plaintiff, in this case was Bill Walker, they have to state everything as to fact and law, as to what the issue is. And then the defendant, and in this case it was the Solicitor General of the United States because the defendants were members of Congress. The suit was titled Walker versus Members of Congress. I don't know if I mentioned that. But so the Solicitor General basically had to sign off on whether or not what Walker was saying was true as to fact and law, and in fact they did. So basically what the suit did is it forced Congress to say in a court of law that they are not going to obey the Constitution, that they are not going to call a convention. So at that point, when the suit, when it appeared that the suit failed, I also realized that really it doesn't matter what the court says the Constitution means. It only matters what the people say it means. And I knew that in terms of political science, as soon as we get enough people saying the Constitution means we're going to hold a convention, that we will indeed have a convention. So I, ran around the country a few times and talked to a lot of people about it, and been fishing around, ways to raise awareness of a convention. last September of 2011, Professor Lawrence Lessig at Harvard had a conference on the quote-unquote Constitutional Convention. And I had been in touch with Professor Lessig for about 3 years, and so it was a great conference that we had there. And basically, it was a lot of conservatives showed up. Mark Meckler from the Tea Party showed up. And then you had a lot of liberals, folks like myself and Lawrence Lessig. Some other folks were there, too, who were more left progressive. So what we found out, though, at the conference is that when you get people from opposite ends of the political spectrum, when you get them together in the same room, you find out that nobody wants to talk about wedge issues. Nobody wants to talk about subjective issues, the civil issues, amendments, about whether, how someone should live their life. And what you find is people want to talk about the structural issues. And so...
No, that's okay. Actually, let's talk about that for a second. What the difference between an Article 5 convention and a constitutional convention? Many of these state applications actually refer to this Article 5 convention as a constitutional convention right in the applications. But there is a difference, and it is good to know what those kind of limitations are under Article 5.
Because the Constitution that they drafted in 1787, because that was a unique legal document, it never, that type of government for the people and by the people, yeah, and it was the best that they could do for right then because they had common sense. They knew at some point, with the advent of time and change, that adjustments would need to be made, so they left the committee, obviously. The difference between a constitutional convention and the Article 5 convention is that when they wrote Article 5, they were very clear not to put a self-destruct button in there, not just to say, hey, if you ever want to have a convention, anything goes. And what they say in Article 5 is that the convention, whether it's Congress or a convention proposing amendments, the law is you can propose amendments to this Constitution, is the quote. So the difference between the two is that a constitutional convention is to draft a constitution. The Article 5 convention is to draft amendments to the Constitution that we have. And whatever is drafted at the convention, it doesn't mean anything unless you can get 3/4 of the states to agree to those proposals. And the reason the framers put that principle of 3/4 in the Constitution is because whatever the idea is, whether it's a conservative idea or a liberal idea, you're going to have to get all of one side signed on, plus at least half the other, or it's going nowhere. So they didn't put a self-destruct button in there. A constitutional convention is not dangerous. It's simply a way for the people to come together and ascertain whether or not we need a new amendment or 2 or 3 proposed to the Constitution.
Now, you actually pointed out something to me that I thought, I hadn't noticed it before, and I actually posted it up on the articlev.org Facebook wall, the applications of Virginia and New York. The first 2 applications, immediately after the ratification of the Constitution, they go right for the Article 5 amendment applications, and they were just general open calls, and it was great reading that, and I was really glad that you pointed that out to me, and I thought they were real beautiful applications, very eloquently expressed, and I really got the feeling that those were, because they were contemporaneous to the time, that they were very accurate to the feelings of our founding fathers and how they wanted this convention to occur, and they really didn't waste a second. They got right to it, and I thought that was amazing, and I felt that may have been the most persuasive element that really convinced me that this was something that was supposed to be there all along in our government, and it's been denied by our Congress, It's been a phenomena. And do you think that Congress is in violation of the law and has been for quite some time, or do you think it's just ignorance is bliss?
Probably a little bit of both. Well, a lot on the first one. Yeah, I mean, the Constitution says that as soon as 2/3 of the states cast applications, as soon as those hit the doorstep of Congress, they got to call it. They don't have a choice. I guess, the metaphor that I like is, once we get, because 3/4 applications today would be 34 states. So, it's like it's like the American public is in an elevator. And as soon as we get to that 34th floor, the door's open and we walk out onto the floor and decide what we want to do. The third ever application was cast by Georgia in, I believe, 1832. And to paraphrase that application, it says, in their application, it says, look, the Congress is taking powers unto itself that was never designed to have. The court is taking powers unto itself it was never designed to have. And it's making the people hate their government. And that's just, such a huge phrase. It's making the people hate their government. Yeah, so they're in violation of the Constitution. And in fact, that's what Walker versus members of Congress did, is it forced them to say openly in a court of law that they're not going to obey the Constitution. The point that I'm making here is that we're actually still in the same place that we were in 1832. We have a Congress holding up a convention so that the people aren't able to get together and find out what we need to do, nonpartisan stuff, what we need to do so we can go back to our lives and enjoy them.
The last ditch chance to save the Constitution from our politicians. The Constitution, let's just say it, the Constitution does belong to us. It doesn't belong to Congress. It's our Constitution. It begins with we the people. And the sheriffs are the last line of defense, as you've always said. Tell us about your experiences with the sheriffs that you've been talking to lately, and what we hope to see from them.
And this Sheriff Gil Gilbertson in Josephine County, Oregon, sent out a white paper in February 2011. Basically, the white paper said, look, the Forest Service is coming into my county. They're not coordinating with me. They're looking at me like I'm their servant. Lo and behold, 7 or 8 other sheriffs said, hey, me too. That's happening here. Well, I called Gil Gilbertson in February of 2011, and I told him, I said, if you're having a problem with the federal government, there's a tool for that, and it's called a convention. Seeing this year on trying to get the sheriffs together on this, and I think it was the beginning of April, I drove up to Alturas, California, which is in the very top the northeastern corner of California. And a sheriff up there named Mike Poindexter had another one of these meetings of what, for lack of a better term, and they call themselves this too, constitutional sheriffs. Because the sheriff is an elected office, it's where the buck stops constitutionally. They are the highest law enforcement official in a county. Because it's been proven that members of Congress are breaking the law, they're not obeying their oath, and they're not obeying the Constitution and issuing the call for a convention, that the sheriffs could actually, if they ever run across the path of a member of Congress, they could actually arrest a member of Congress for breaking their oath and for breaking the Constitution. So I've been trying to persuade and reason with these sheriffs that what they ought to do is get together and tell the American public and all federal officials that they intend to do their job, and that if the 112th Congress, now we're getting close to the 113th Congress, there's going to be a new Congress, but if the members of the 112th Congress, if they don't issue the call for a convention, then the sheriff actually has no choice themselves but to arrest them. Otherwise, they're aiding and abetting the breaking of the Constitution. Is that if they did do that, in the blink of an eye, they would have half of America or more at their back saying, Right on, Sheriff. Go get them because we're sick and tired of them.